And day 3 of the conference, and everybody's still looking gorgeous and bright-eyed and eager for the fray ahead. And we're looking very much to this particular session. I should say Happy International Women's Day to you all, and we're looking forward to marking this, in addition to the breakfast that has just taken place, by a really marvellous session on the independence of the judiciary. At the end of the session, there may be an opportunity, we'll see how the timing goes, to bring a message from a young colleague from Zimbabwe. I hope that we will have time for that. And also to bring the delegates at large news of what we are calling the Goa Declaration, which was signed by bar leaders on Sunday. Seems about 3 weeks ago Sunday, but it was only a couple of days ago. This plenary session is being chaired by the former Chief Justice of my own jurisdiction, the famous Northern Ireland. And it's a remarkable feature of a Commonwealth event that small jurisdictions get the opportunity to appear with much larger friends from larger jurisdictions. And Sir Declan Morgan is now enjoying his post-Chief Justice tenure as Chief Justice in Northern Ireland, and he sits from time to time in the Supreme Court of the United Kingdom and in the Privy Council. He has been a great supporter of the legal profession in Northern Ireland and a great supporter of the Commonwealth Lawyers' Conference. In particular, he has been participating as speaker and keynote at least at the last 2 conferences in Zambia and in Nassau, and it's a really great pleasure for me as conference chair to introduce my former Lord Chief Justice, Sir Declan Morgan, who will take over proceedings from here. Thank you.
Good morning, ladies and gentlemen. Can I start off by saying that I am deeply disappointed to find that I am the chair of this particular session. As Brian indicated, I retired a short time ago as Chief Justice of Northern Ireland, and my successor, I'm delighted to say, Lady Chief Justice Siobhan Keegan, is the first head of jurisdiction in the United Kingdom who is a woman. And it seemed to me that it would have been so incredibly appropriate on this International Women's Day for her to be here instead of me as the chair of this session. And I tried very hard to persuade her that that's exactly what she should do. But I'm sorry to say that she had other commitments which prevented her from taking on that role. But I do, on her behalf, send the good wishes of the Northern Ireland Lady Chief Justice, the first head of jurisdiction in the United Kingdom, to all of you on this International Women's Day. We have 4 extremely distinguished speakers who are going to make relatively short presentations on the issue of strengthening, safeguarding and strengthening the independence of the judiciary. The first speaker will be the Honourable Mrs. Justice Agyemang. She's a Ghanaian-trained judge with over 3 decades of judicial experience at all levels of the judiciary in 4 Commonwealth jurisdictions. She joined the Ghanaian bench in 1991 as a magistrate, moved into the Circuit Court and the High Court in 2002. She was appointed an expert High Court judge for the Commonwealth Fund for Technical Cooperation and served in a number of jurisdictions in that area, was appointed to the Justice of Appeal in Ghana in 2015, and is currently the Chief Justice of the Turks and Caicos Islands. So she's certainly done her rounds through various areas of the Commonwealth. The second speaker is Nene Amegatcher, who's Justice of the Supreme Court of Ghana. He had a distinguished civil practice in corporate and commercial law, constitutional law, and Brian's favourite, alternative dispute resolution. Any kind of mediation, Brian thinks, is to be commended. Among his high-profile clients were the World Bank, for whom he served as a consultant, and he served as chair or president of the Ghanaian Bar Association. He's a lecturer at the Ghana School of Law, and in 2018 was nominated to the Supreme Court. Our third speaker is the Chief Justice of Malaysia. We just met this morning, and I was delighted to do that. She has had a career, distinguished career, as a judicial commissioner, which she took on in 2006. She served in the High Court of Justice from 2007 to 2013. And then in 2013, she was elevated to the post of Judge of the Court of Appeal of Malaysia. She served there for about 6 years before moving into the Federal Court in 2018. And on the retirement of the 9th Chief Justice of Malaysia, she was appointed as his successor in May 2019. She became the first woman in history to hold the office of Chief Justice of Malaysia, creating another first for the holder of the top judicial office after Malanjam became the first person from the Borneo States of Malaysia to ascend to the office. So she rather beat my own Chief Justice to the top post. Our final speaker, who I think we're using rather plentifully today because she's already had a starring role in the breakfast for International Women's Day, is the Honourable Dr. Justice Nagarathna. She started practice in 1987, was elevated to the High Court of Karnataka in 2008, practiced in a wide variety of areas, was the first lady from the bar to be appointed a judge of the High Court of Nagarathna. She's contributed to the book Courts of India, released by the Supreme Court, with a chapter on the courts of Karnataka, and was chairperson of the committee dealing with the Canada translation of the book Courts of India. She was elevated to the Supreme Court of India on the 31st of August 2001. I'm sure you will agree, a fine array of speakers. I'm going to ask Chief Justice Agyemang now to start us off. Thank you.
Good morning to all delegates. Our task today is to explore the concept of judicial independence, a concept that is essential to the rule of law, to good governance, and is therefore pivotal to democracy and to our quality of life. I choose to address it by posing a question as to whether it is a destination we aspire to reach or a horizon of never-ending possibilities. I will assume that every person trained in the law has some idea of the concept. It is recognized and provided for in a number of international instruments and in many national constitutions. I describe an independent judiciary as a well-resourced institution which has strong internal accountability mechanisms and in which capable judges appointed on merit, well remunerated, and who are provided with adequate personal security have no fear of the future because they have security of tenure. They perform their duties without interference from external actors, whether they be governmental institutions or private interests. This summary encompasses what may be the aspiration of every democratic society, which is that in the decision-making process, justice must not only be done, but must manifestly and undoubtedly be seen to be done. Yet there have been failures or compromises made by countries which affect the strength and credibility of the institution, as well as its judges. In this paper, I discuss the ways in which some jurisdictions have utterly failed to assure an independent judiciary, and how some have paid only lip service to it. I also discuss areas of success and conclude by making recommendations on the way forward. I do these having regard to the three-pronged outworking of the concept, which is institutional independence, the individual independence of judges, and the supporting role of other governmental institutions. First, I speak of failures and compromises, and I start with the inadequacy of the resourcing of the institution and poor remuneration. The failure to realize the financial independence of the judiciary from other arms of government has been the bane of the judiciary, which is placed in the position of a beggar for its sustenance. Lack of financial autonomy affects the administrative autonomy of the judicial institution when another arm of government gets to dictate what it considers to be important to the judiciary's operations. This works out in budgetary cuts that sometimes curtail the judiciary's operations and deprive it of projects that improve efficiency of the judicial process, such as capacity building programs and programs that enhance access to justice. Lack of financial autonomy also contributes to the perception of the compromise of independence, especially when such budget cuts and other deprivations appear to be punitive or a reward depending on whether the executive arm has won or lost a case before the courts. Lack of guarantees regarding the determination of the remuneration of judges sometimes adversely affects judges and places them at the mercy of the public purse holder. This happened in Mozambique not too long ago when the harmonization of public sector salaries affected the determination of salaries for judges apart from Supreme Court judges, and it was described as a crisis of the democratic rule of law. Also, while the compensation clause doctrine is reproduced in many national constitutions and provides that the remuneration of judges shall not be varied to their disadvantage, the remuneration is sometimes whittled away through tax regimes that change every so often or through high inflation when there is no accompanying salary review mechanism. I now speak of the lack of provision of security. Tragic incidents come without warning, and the threat or apprehension of harm may affect the independence of a judge in difficult cases that expose the person of the judge to danger. Yet it is apparent that in some countries there is no provision of close protection for judges, even though routinely judges in the discharge of their duties, the criminal jurisdiction, deal with persons accused of terrible crimes, some of which may belong to gangs or cartels capable of reprisals. In Ghana, it took the murder of 3 High Court judges for the government to provide security for judges. There have been failures in the appointment and promotions process, and lack of transparency has led to accusations of impropriety, especially where there is the perception that certain appointments were made for reasons other than on merit. Beyond the lack of competence in decision-making, which results from such appointments, is the phenomenon of cronyism and other factors of compromise, which may produce judges beholden to interests that affect their independence in their decision-making. Indeed, compromised appointments have placed on the bench persons with questionable lifestyles and in whom the public has low confidence, affecting the strength of the institution and the perception of independence, which is so crucial to its role as a governance institution. To avoid accusations and suspicions of cronyism, corruption, or improper control by the appointing authority, which is usually the head of the executive arm, some countries have endeavored to provide measures to promote transparency and to ensure at least a perception of fairness and impartiality in the process. And they do this by the use of judicial commissions or councils. I'll refer to them as commissions. These commissions employ measures such as the introduction of systems of application, conduct of interviews, among others, to ensure impartiality in the selection process towards the judicial appointments. However, there are fault lines where the commissions themselves lack accountability and fail to provide clearly defined internal mechanisms ensuring transparency in their operations. Sadly, some commissions, cowed by executive authority, have operated as rubber stamps of the executive arm in the area of appointments, discipline, and termination of appointments. Sometimes the lack of effectiveness of the Commission is exposed by either the overt control of the Commission or the disregard of it by the appointing authority. This is what happened in Ghana in 2015 when the President appointed Supreme Court justices without relying on the recommendations of the Judicial Council, a situation which unhappily was not censured by the Supreme Court in its judgment in respect of a suit challenging his actions. Also, appointments that wear political colors and the phenomenon of court packing by the executive, especially in places where there is no limit to the appointments, dents the reputation of and questions the effectiveness of such councils or commissions. One other area in which judiciaries are rendered ineffectual to uphold the rule of law is the failure of other arms of government to comply with the judgments of the court. This impacts upon the independence of the judiciary in no small measure. And while courts have the power to hold persons in contempt of its orders, this is not always advisable in nascent democracies where the alleged contemnors are governance institutions. Nor is it easy or even practicable to assume that jurisdiction of contempt where the governments are democratic in name but autocratic in operation. In these circumstances, the judicial administration may itself be on shaky ground, as its officers who may lack security of tenure become subject to reprisals when enforcement is pursued as it should be. Indeed, in some jurisdictions, the position of a judge is not without fear of the actions of a vengeful executive arm of government if a judge's decisions are unfavorable to government. Such a judge may be targeted as being in opposition to the government, and reprisals in the form of dismissal, withholding of contract renewal, or refusal to give requisite confirmation to further appointment or promotion of the judge is not unheard of. In recent times, Kiribati has come under the microscope for such activity after the Chief Justice and later 3 appellate judges were suspended by the government following a ruling that prevented the deportation of a judge unpopular with the government. The court's judgment was described as, I quote, autocratic judicial tyranny by the President, who, after suspending the Chief Justice, replaced him with the Attorney General as the acting Chief Justice. In recent years, we have heard in the news about Poland that a disciplinary regime for judges has left judges vulnerable to control by the executive. And though it has been widely criticized as forming part of an autocratic agenda of the ruling coalition and an attempt to put an end to judicial independence, the fight goes on. I have so many other examples, including Ghana's judicial dark days in the 1960s, when the president annulled the judgment of the court by an executive instrument, dismissed the Chief Justice who sat on the case, constituted a new bench which retried persons who had been acquitted of charges of attempted assassination of the president, found them guilty, and condemned them to death. In recent times, there has been a very unfortunate trend emerging in which some members of government, sometimes in very advanced countries, have publicly questioned the correctness of court judgments that find disfavor with them, hinting that the judges exhibited bias or were otherwise influenced by political opponents. Such conduct weakens the judicial institution, which is seen as corruptible, and the judges as corrupted, weakening the perception of the independence of judges. I now speak of discipline, or the lack of it. The inability of the judicial institution to carry out the disciplining of its officers where allegations of impropriety in office merit such is a failure of independence. While some judiciaries lack laid down procedures for disciplining its members, some countries do have such but fail to use them. Thus, when in Ghana, some judges were filmed, whether properly or improperly, in the act of taking bribes, that the judicial administration failed to lead in prosecuting such conduct was seen as a failure of credibility, even though the said judges were dismissed from office. I will talk about the lack of security of tenure. And because of time, I will limit myself to the Two phenomena: contract judges and acting judges. The tenure of judges in many jurisdictions for the most part is assured, and a judge will work until the age of pension determined for judicial officers, unless for reasons of incapacity or bad behavior, the judge is removed. Regarding contract judges, who are typically appointed for renewable terms of 2 to 3 years, there has been much concern and much discussion that the lack of security of tenure compromises the independence of such judges, who are said to be placed at the mercy of the appointing authority and may have to curry favor with it in order to remain in employment. It is for the same considerations that recently the phenomenon of acting judges came under unfavorable scrutiny in the Ugandan case of Kabumba and another against the Attorney General. In that case, acting High Court judge appointments for 2-year periods made by the President of Uganda were challenged successfully at the Constitutional Court of Uganda, which held it to be unconstitutional. The learned justices appear to have been swayed by, among other matters, the forceful argument that the appointments would subject the acting judges to the control of the appointing authority and were therefore contrary to the dictates of the Constitution. I will talk about the role of the media as another actor that affects the independence of the judiciary. The fear of an unfriendly media environment that questions the competence of judges, opens them up to ridicule or hate, can affect the independence of a judge in no small measure. The converse is also true, for a judge who carries favor with the media may pander to the views of the public in decision-making. The media, with its power to disseminate information and its wide reach, sometimes impacts on judicial independence in the following circumstances. Sometimes there's reporting of incidents that assumes a verdict before a trial is conducted. And sometimes the reporting places either the judge or the judicial institution in an unfavorable light as being either incompetent or compromised. Court reporting is done without knowledge of the facts, which are easily ascertainable by ordinary diligence. There is misreporting of the dealings of the courts by reason of misinformation or a misapprehension of legal terminologies and commentary on judgments. The reporting that derides court decisions doesn't help, and legal issues that are politicized lend themselves to weakening the independence of the judiciary. But I will be painting an unfortunate and untrue picture if I did not point out that efforts have been made by some jurisdictions towards attaining judicial independence. These include improved arrangements for funding, remuneration, appointment procedures, discipline, and security of tenure. I provide a short summary of these. A number of countries have constitutional provisions to ensure the adequate resourcing of the institution. These countries include Zambia, the Gambia, Ghana, Canada, South Africa, Jamaica, Namibia, Trinidad and Tobago, Malaysia. And in the appointments area in the United Kingdom, the Constitutional Reform Act of 2005 established an independent judicial appointments commission, which has done a very good job so far. Because of time, I will skip to the recommendations that I make. I make these recommendations in the light of the theme, which is how to strengthen and safeguard judicial independence. First, I point to a credible appointment system. And so I zone in on accountable judicial councils or commissions. As I have pointed out, there is the increasing use of these councils. And to ensure their independence and effectiveness, it is recommended that the legislation on the composition of and the appointment process of the members of the judicial commissions or councils and the process or mechanism for their selection should contain accountability provisions to ensure the integrity, impartiality, and competence of the persons selected to be members, especially the chairperson. The commissions must be enabled to establish internal mechanisms that ensure that their nominations adhere to clear criteria for appointments, transparency in selection, commencing with an application process, a credible interview process or process of examination, and are based solely on the needs of the judicial institution and the merit of applicants for judicial positions. There must be appropriate wording in national constitutions or legislation to avoid the situation where their recommendations may be ignored by the appointing authority without cause. In Ghana, a recent demonstration of the check on executive power by the process of parliamentary vetting, when the nomination of 4 persons for appointment to the apex court by the executive resulted in the appointment of 2 of the 4 nominees, reveals the benefit of the involvement of another governance institution in the process of appointments, and leads me to the recommendation for a push for greater involvement of all arms of government in the process. A clear system of discipline with a will to enforce it must obtain. Judiciaries must not lend themselves to accusations of the old school tie that shields wrongdoers from consequences. Codes of conduct with disciplinary regulations that will define the mode of discipline must be a high priority in judicial administration. These will ensure decisive action against misconduct. There must be internal institutional mechanisms for accountability. Assignment of cases and paneling of judges must be done through mechanical means and or digital means, anything that removes it from human manipulation. Judges must, and the institution must be insulated from internal and external influences. And I have said that judges must be removed from politics and must be discouraged from hobnobbing with politicians. And while they may hold political views, it is recommended that their views be not trumpeted so as to make their decisions predictable as biased in favor of their political leanings. The institution must encourage circumspection in the lifestyles and social interactions of judges, including their involvement in certain clubs and societies. Internal pressures from senior judges or the judicial administration may be obviated through internal control mechanisms that will expose such attempts. A recommendation is made for the establishment of an internal ombudsman to promote internal integrity and serve as an accountability body which is granted independence of operations within the institution. The Madrid Principles on the relationship between the media and the judiciary, providing for their beneficial coexistence, must be respected through the cultivation of channels of communication in these ways. A reporter should be enabled to receive answers from the judicial administration before it reports cases, including the proper use of judicial words and their meanings and court terminology. I think my time is up. Let me speak of that there should be provision of security of tenure, provision of personal security, institutional funding and remuneration should be addressed. I'm sorry that I could not finish it all. But may I say this? You see, I posed the question at the beginning, and the question was whether judicial independence is a destination or a horizon. And I've ended up with it, that it doesn't really matter. A destination we aspire to reach, a horizon, infinite possibilities. Thank you very much.
Thank you. Justice Amegatcher.
Good morning. I bring you greetings from Ghana and West Africa. My presentation this morning will be focused specifically on Ghana in particular, and in general, the common law countries in West Africa, namely Nigeria, Sierra Leone, and the Gambia. I'm going to make certain assumptions that we all know what judicial independence is, and we also know the importance of judicial independence in a democracy and to the sustenance of the rule of law. I'm going to make these assumptions, and when you get my paper, which will be circulated at the end of this conference. You get all the details. Now, when we talk about judicial independence, we are looking at certain elements such as separation of powers, financial autonomy, administrative autonomy, processes for the appointment of judges, security of tenure of office, immunity from prosecution, conditions of service, removal and retirement, and measures to ensure judicial accountability. They are all well captured in my paper. I'm going to concentrate within the time at my disposal in dealing with three, namely financial autonomy, administrative autonomy, and the appointment of judges. The 1992 Constitution of Ghana has beautiful text and provision regarding judicial independence. And when you read it, the Latima House principles have been captured beautifully in the Constitution. For instance, Article 1253 provides that the judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the President nor Parliament, nor any organ or agency of the President or Parliament shall have or be given final judicial power. The Chief Justice is the head of that arm of state. And when we go into Article 127, and the same applies to most of these common law countries in West Africa, 127 says, in the exercise of the judicial power of Ghana, the judiciary, in both its judicial and administrative functions, including financial administration, is subject only to this Constitution and shall not be subject to the control or direction of any person or authority. Neither the President or Parliament nor any person acting under the authority of the President or Parliament, nor any other person whatsoever shall interfere with judges or judicial officers or other persons exercising judicial power. These are beautiful provisions. When you read them, you think that the country is on all course to practice the rule of law and democracy. So we see this text in many other jurisdictions. They are there. And we would have then complied with various provisions, as I said, like the Latima House principles, which provides for judicial independence as well as the independence of the legal profession. Now, let me take the first one. I have mentioned the constitutional provision relating to financial autonomy. But in reality and in practice, is there financial autonomy? In reality and in practice, the judiciary every year is supposed to have a budget. The budget is supposed to be sent to the president. The president is not supposed to interfere or to change anything regarding the budget that is sent to him. The president, after receiving it, is supposed to send it to Parliament for approval. So over the years, that has been the norm. The budget is sent, the president receives it, sends it to Parliament, it is approved, and then after Parliament approves it, the budget for the judiciary for the year is provided. But then what happens? In reality, there's a difference between approval of your budget and the release of funds for your day-to-day administration and for the efficient functioning of the judiciary. And the aspect that affects judicial independence that all of us will have to discuss and take a decision is sometimes it will have to take the judiciary or the Chief Justice to either go to the president to beg or the Minister of Finance to go and beg for budgetary allocation approved for the judiciary to be released to the judiciary. There can be a whole quarter, like the quarter of January, February, March, that not a single dollar or CD will be released to the judiciary in order for it to perform its function. These things affect the independence of the judiciary because that organ of state now will have to be at the beck and call of the executive arm of government. That is not good. And sometimes when government feels that the judiciary is not coming out with decisions which favor the government, they can use the release of funds as a way to clip the arm of the judiciary and prevent it from doing what it's supposed to do. The second that I want to touch on is administrative autonomy, which is also provided beautifully in the text of the 1992 Constitution, which means the judiciary is supposed to exercise its own administrative powers. But in reality, you have interference coming in from the executive relating to the procurement. Some of the vendors that are supposed to supply things to the judiciary have political contacts with various ministers and politicians. And they then come and impose their vendors or people that they have promised to give job to on the judiciary to select these people or to allow them to supply various things that the judiciary needs for its services. These things also affect the independence of the judiciary. And recently, there was a case in which the Judicial Council, which is the body that works with the Chief Justice to administer the judiciary, took a decision regarding judges who were retiring and what to do with the official vehicles which they were using. Some were asked to purchase the vehicles and use them in their retirement. But then the Auditor General came up with a report that the vehicles should be retrieved from those judges because they were supposed to seek the approval of the Minister of Finance before vehicles are released to judges. These are interferences with the administrative autonomy of the third arm of state, which has been provided in the text of the Constitution. And these are not the only example. Time will not permit me, but when you get my paper, you can see this in detail. The final that I want to touch on in this presentation is appointment and promotion of judges. As Justice Agyemang has just said, the appointing process ought to be transparent, and it ought to be made by an independent judicial body. If appointing process is left in the hands of the politicians, forget it. They will do everything. They will appoint the wrong people at the wrong time. They will appoint people who are not qualified into that position. They will appoint political cronies. And this will be a blight on the independence of the judiciary. In Ghana, we have a beautiful provision that provides for the establishment of an independent body called the Judicial Council. That is the appointing body. The Judicial Council has representatives from the Ghana Bar Association, the various hierarchy of the courts in the country, and other bodies. But apart from that, the president of the country appoints 4 nominees and has the Attorney General also on the body, making 5 representing the interests of the president. We had a problem with the phrase in the Constitution that appointing of judges shall be made by the president acting on the advice of the Judicial Council. The phrase acting on the advice of the Judicial Council, in the view of some of us, when used in constitutionalism, is mandatory, is binding when the advice is offered. But in reality, when the Judicial Council offers the advice, the president could pick and choose from the recommendations. So the Ghana Bar Association, and when I was president, took the matter to the Supreme Court for interpretation. Unfortunately, the Supreme Court did not do a good job. At that time, I was not on the Supreme Court, so I'm not criticizing myself. Yeah. I took the matter to the Supreme Court, and the Supreme Court said, acting on the advice of is not binding on the president. Recommendation in consultation is also not binding on the president. In effect, what the Supreme Court said was that acting in consultation with and on the advice of, which were two different phrases used in the Constitution, all mean the same thing. Thereafter, whenever the Judicial Council made recommendations to the president could pick and choose from the recommendation. And this is a challenge we have been grappling with, to the extent that now, sometime last year, there was a list circulating from the Attorney General, writing to the chairman of the Judicial Council, informing the Judicial Council that the government had decided to nominate certain people for promotion to the Court of Appeal. And you look at the list and the basis, there was actually no basis for the names that were sent to the Judicial Council. So for us to truly exercise the proper role and function so that the judiciary will be independent, the appointed body, if it is an independent appointed body, should be absolutely and totally neutral. And their appointing process, when they make the recommendation, it should be final. And before I take my seat, I'll recommend the practice that is ongoing in Kenya. The Kenyans have been able to resolve this in a particular way in their 2010 constitution, to the extent that their Judicial Services Commission, when they make recommendations for appointment or promotion to the president, it is binding on the president. The president has no option in the matter. The president is only to forward it to Parliament, and Parliament will do what it's supposed to do, and the person is supposed to be appointed. I think we have come a long way as a Commonwealth Lawyers Association, and these are critical areas that we have to look at so that we strengthen the independence of the judiciary in their respective jurisdictions. Thank you.
Chief Justice Taiman, Tengku Taiman.
Mr. Brian Spears, President of the Commonwealth Law Association, the Honourable Sir Declan Morgan, former Chief Justice of Northern Ireland, Chair of the plenary session, honourable panelists, distinguished delegates, ladies and gentlemen, Assalamu alaikum warahmatullahi wabarakatuh, and a very good morning. I would like to begin by thanking the organizers for giving me the honor and privilege of participating in this plenary session, and congratulations to the Commonwealth Lawyers Association for their exceptional efforts in bringing together this biennial conference. At a time when the rule of law and the independence of the judiciary are under attack in many parts of the world, it is imperative that we come together to reaffirm our commitment to safeguard and strengthen the independence of the judiciary. I stepped in as the Chief Justice of Malaysia at a challenging time when the court's image has been battered with disgraceful allegations of abuse of power and also controversies involving top judges. The allegation against the judiciary then was that the judiciary was subservient and beholden to the executive. I therefore made it my mission upon my appointment in 2019 to defend the independence of the Malaysian judiciary. I am grateful for this opportunity to share some perspectives from the Malaysian context. The starting point on safeguarding and strengthening the independence of the Malaysian judiciary is the constitutional and legal framework contained in the Federal Constitution and the Judicial Appointments Commission Act 2009. In the interest of time, I will focus my speech firstly on the constitutional safeguard of judicial independence and its subtopics of judicial power and judicial review. Secondly, on the process of appointment and promotion of judges. And thirdly, on challenges of judicial independence. Coming from a country with a written constitution, I can attest to the crucial role that constitutionalism plays in our work. While constitutionalism connotes, in a sense, limited government or a limitation on government, one important characteristic or feature of constitutionalism is an independent judiciary. The spirit of constitutionalism in Malaysia safeguards judicial independence through the following two aspects. First, the separation of powers doctrine, and second, judicial review. Like most Commonwealth jurisdictions which are based on Westminster model of government, the approach to separation of powers that the Malaysian Federal Constitution takes is that there is some degree of fusion between the executive and the legislature on the one side, and complete separation of the judiciary on the other. The crucial significance of the separation of powers doctrine is entrenched in Article 4, Clause 1 of the Federal Constitution, which stipulates that the Federal Constitution is the supreme law of the Federation of Malaysia, and that all laws passed after Merdeka or Independence Day shall, if inconsistent with the Federal Constitution, be void. Because the Federal Constitution is not self-executing and cannot protect itself proactively from breach, it relies on the judiciary to ensure that Article 4, Clause 1 is given effect to. The judiciary undertake to exercise this role and function through Article 4, Clause 1, read with Article 121 of the Federal Constitution, which vests the judiciary the judicial power. Recently, the Federal Court reaffirmed that the doctrine of separation of powers is part and parcel of our Federal Constitution, and that the doctrine is also housed in Article 4, Clause 1. Thus, by constitutional design, the judiciary is completely independent of the executive and the legislature. Further, judicial independence and separation of powers are recognized as features in the basic structure of the Federal Constitution. This means that the concepts of judicial power, judicial independence, and separation of powers are sacrosanct in our constitutional framework, and inextricably linked to the concept of judicial power is the concept of judicial review. The power of the Malaysian judiciary to review the legitimacy of legislative and executive actions is an essential component of its independence from these other branches of government. It is a power that enables the judiciary to perform its inherent function of checks and balances. The power of constitutional judicial review is ingrained in Article 4, Clause 1 of the Federal Constitution of Malaysia. If a law is found to be unconstitutional, the judiciary has a duty to strike it down as being void to ensure that the Federal Constitution remains the supreme law of the land. My discussion on judicial review naturally brings me to the topic of ouster clauses. An ouster clause is a provision included in a legislation which seeks to limit or exclude judicial review of acts or measures undertaken by the executive. The power of the judiciary to independently review government actions or measures can be severely curtailed or even entirely eliminated by means of an ouster clause in a legislation. Last year, the Malaysian Federal Court handed down two important judgments declaring ouster clauses to be unconstitutional. Both of these decisions observed that ouster clauses sought to limit the exercise of the judiciary's essential function or power to check and balance the exercise of executive's actions, measures, and power. This was found to have amounted to an incursion into the very essence of the judicial power itself, which was found to be in violation of Article 4, Clause 1 of the Federal Constitution. The ouster clauses were accordingly struck down as being void by the Federal Court. The principles that I have discussed so far clearly reflect the constitutional safeguard of the independence of the Malaysian judiciary in relation to the judicial power. I now move to the other aspects of constitutional safeguard. Undeniably, one of the main factors to safeguard and strengthen the independence of the judiciary is that there must be security of tenure of office and remuneration of judges. In Malaysia, this security is prescribed in Article 125 of the Federal Constitution. Malaysian judges shall hold office until he attains the age of 66 years or such later time, not being later than 6 months after he attains that age, as the King may approve. Grounds of removal prior to retirement age is based on well-defined circumstances under the law. The Judges Remuneration Act 1971 established salaries and pensions of judges. By Clause 7 of Article 125, the remuneration and other terms of office, including pension rights of a judge, shall not be altered to his disadvantage after his appointment. The next constitutional safeguard is specified in Article 126 of the Federal Constitution. This relates to the power conferred on the courts to punish for contempt any person who, by word or deed, interferes with the administration of justice or challenges the dignity or independence of the courts. Another safeguard is provided by Article 127 of the Federal Constitution, which stipulates that the conduct of a judge of the Federal Court, the Court of Appeal, or a High Court shall not be discussed in either House of Parliament except on substantive motion, of which notice has been given by not less than 1/4 of the total number of members of that House, and shall not be discussed in the Legislative Assembly of any state. Another important aspect of judicial independence is judicial immunity. Several legislations conferred immunity to judges from the law of torts. Section 5 of the Government Proceedings Act 1956 provides for the liability of the government in tort for any wrongful act done or neglect or default committed by any public officer. Under Section 6, subsection 3, no proceedings shall lie against the government by virtue of anything done or omitted to be done by any person while discharging or purporting to discharge any responsibilities of a judicial nature vested in him, or any responsibilities which he has connection with the execution of judicial process. And pursuant to Section 14 of the Courts of Judicature Act 1964, no judge or any person acting judicially shall be liable to be sued in any civil court for any act done or ordered to be done by him in the discharge of his judicial duty. Also, reports of judicial proceedings, including judgments, sentences, or findings, enjoy absolute privilege under Section 11, subsection 1 of the Defamation Act 1957. I now move to the appointment and promotion of judges. Objectively speaking, although the executive arm plays a vital role in the appointment of judges of the superior courts in Malaysia, there are constitutional safeguards. Article 122B of the Federal Constitution sets out a comprehensive and multi-tiered process of consultation between the Prime Minister, top judges, the Judicial Appointments Commission, the King, and the Conference of Rulers preceding every judicial appointment. To safeguard the independence of the Malaysian judiciary, the Judicial Appointments Commission was established within the Judicial Appointments Commission Act 2009. Essentially, the Act was promulgated to improve and complement the constitutional method of appointing judges of the Superior Court. The Act ensures that only those with proper qualification, integrity, and caliber are appointed to the judiciary. The process and criteria for selection of candidates are enumerated. It is worth mentioning that Section 2 of the Act speaks of upholding the independence of the judiciary, where it states inter alia that the Prime Minister must uphold the continued independence of the judiciary and must have regard to the need to defend that independence. As set out in the Act, appointments to the judiciary are based on identified criteria. First, integrity, competency, and experience. Second, objective, impartial, fair, and good moral character. Third, decisiveness, ability to make timely judgments, and good legal writing skills. Fourth, industriousness, and ability to manage cases well. And fifth, physical and mental health. In addition, a serving judge will not be eligible for promotion if he has 3 or more pending judgments or unwritten grounds of judgments that are overdue by 60 days or more from the date they are deemed to be due. To strengthen the independence of the judiciary in terms of appointment of judges, the Act requires that the Judicial Appointments Commission takes into account the need to encourage diversity in the range of legal expertise and knowledge in the judiciary. Another pertinent provision in the Act which serves to safeguard and strengthen the independence of the judiciary is Section 34, which provides that any person who otherwise than in the course of his duty, directly or indirectly, by himself or by any other person, in any manner whatsoever, influences or attempts to influence any decision of the Judicial Appointments Commission or any member thereof, commits an offence, and shall, on conviction, be liable to a fine not exceeding 100,000 ringgit or to imprisonment for a term not exceeding 2 years or to both. That said, the proposed changes to the Judicial Appointments Commission Act and the Federal Constitution to remove the role of the Prime Minister in the appointment of judges would, in my view, further strengthen the independence of the judiciary. Continuing legal education to the judges is crucial in ensuring that the judiciary safeguards its independence. To achieve this, although we have yet to establish a properly structured institution to train the judges, the Malaysian judiciary has set up a judicial academy in 2012 under the Judicial Appointments Commission to inter alia plan, organize, and conduct training programs for the superior court judges. Significantly, standards of judicial conduct affect the independence of the judiciary. In this regard, Malaysia's measure in safeguarding and strengthening the independence of the judiciary is encapsulated in the Judges Code of Ethics 2009 and the establishment of Judges Ethics Committee under the Judges Ethics Committee Act 2010. Paragraph 5 of the Code provides that a judge shall exercise his judicial function independently on the basis of his assessment of the facts and in accordance with his understanding of the law, free from any extraneous influence, inducement, pressure, threat, or interference, direct or indirect, from any quarter or for any reason. The Code requires that a judge shall act at all times in a manner that promotes integrity and impartiality of the judiciary. There is also a provision requiring a judge to declare his assets to the Chief Justice and to adhere to the administrative directions issued by the top 4 in the hierarchy of the Malaysian judiciary, i.e. the Chief Justice, the President of the Court of Appeal, and the Chief Judges of the High Court in Malaya and in Sabah and Sarawak, respectively. At this juncture, I would like to share with the esteemed audience my reminder to the Malaysian judges, i.e. that the top judges are only the first among the equals and that judges are not expected to display their loyalty to these bosses, but only to the law. It is my hope that this kind of reminder will assist in safeguarding and strengthening the independence of the Malaysian judiciary. On challenges to judicial independence, the year of 1988 has been dubbed as the eclipse of the Malaysian judiciary as it marks the most devastating attack on the independence of the Malaysian judiciary. The 1988 episode began when several important decisions of the court were seen to go against the government of the day. The tension in the relationship between the executive and the judiciary led to unprecedented removal of the then Lord President, the late Tun Saleh Abbas, and the suspension of 5 Supreme Court judges. 2 of the 5 suspended judges were subsequently dismissed. Judicial independence and public confidence in the judiciary suffered greatly after the 1988 constitutional crisis. Judicial prestige and independence were also eroded by several constitutional amendments which attempted to circumscribe the judicial power to which judges acquiesced until recently. In recent years, there have been further attempts to undermine the independence of the judiciary through unwarranted criticism and intimidation towards judges. Today, innocent and honest judges who diligently perform their duty are targeted by criminals and their cohorts. With the advent of technology, more damage has been done through social media by people out to advance their own interests at the expense of judicial independence. For me, each attack on a judge for a decision delivered by him is a direct attack on the independence of the judiciary, because it represents an attempt on the part of those in the abode of the guilty to navigate and coerce judicial conformity with their own preconceptions. It must be remembered that judges, by the nature of their work, do not respond to criticisms or engage in public debates of their decisions, as judges only speak through their judgments. To conclude, I would postulate that the duty to safeguard and strengthen the independence of judiciary does not lie solely on the judiciary, but the stakeholders of the justice system, in particular the Attorney General's chambers and the bar, while I would work to ensure the independence of the judiciary in the event that spurious allegations are made against the judges and, by extension, the judiciary. It falls on the Attorney General and the bar to come to its defense. Thank you.
And now the Honourable Dr. Justice Nagarathna. Well done.
A very good morning to everybody. Former Chief Justice, Right Honourable Sir Morgan, Chief Justices and judges who are the esteemed panelists, Mr. Brian Spears and distinguished delegates. I know, being the fourth speaker on the subject, I need to be a little briefer, but at the same time, I can hope for complete attention, I think. I thank the organizers for inviting me to share a few thoughts on a very important subject, namely safeguarding and strengthening the independence of the judiciary. I would like to speak more about the concept of independence, and secondly, on how to safeguard and strengthen the independence of the judiciary. We, who are all connected to each other by the Commonwealth, are committed to strengthening democratic institutions and the rule of law, and therefore the independence of judiciary is of prime importance in democracies. We all know that the Commonwealth Latimer House Principles declared, and I quote, "An independent, impartial, honest, and competent judiciary is integral to upholding the rule of law, engendering public confidence and dispensing justice," unquote. This year is the 25th anniversary of the Latimer House process, which commenced with the drafting of the Latimer House Guidelines for the Commonwealth on good practice governing relations between the executive, parliament, and the judiciary. Just 2 days ago, we had the Goa Declaration on the Independence of Judiciary, led by our Chief Justice, Honourable Dr. Justice D.Y. Chandrachud. As I again emphasize, we, the Commonwealth, are guided by the Holy Trinity, which I would say are the liberty, democracy, and rule of law, which are indices of a free and civilized society. This Trinity presides over the destiny of all free societies. The significance of rule of law to the process of democratization creates a unique, important role for the courts. Where independence exists, courts are able to be more forceful mechanisms for defense of constitutionalism and justice. The importance of judicial review by courts layers in judicial independence and makes this requirement additionally compelling. In my view, only an independent and an impartial judiciary can effectively exercise its power over judicial review. Judicial decisions rendered by exercising the power of judicial review are the most significant citus for judicial independence to be secured. Historically, in the common law world, judicial independence has been seen as a necessary prerequisite for both maintaining the rule of law and for ensuring adherence to a scheme of separation of powers. In a more recent drafting of the Constitution of South Africa, the fundamental structural protections for the judiciary were identified to be security of tenure and non-reduction of salary. While these two factors relate to individual judges and their independence, in my view, institutional independence of the judicial organ as a whole is distinct and important. The focus of institutional independence is on ensuring an appointment process which upholds independence of the judiciary and an administrative independence of the courts. Now let us define independence of the judiciary. At the most basic level, judicial independence is related to the notion of conflict resolution by a neutral third. Political insularity is critical to the independence of the judiciary. In formulating a general definition of judicial independence, most scholars have placed a great deal of emphasis on impartiality and insularity. Impartiality can be thought of as related to judges' attitudes and beliefs, as well as their behavior in relation to particular political and social actors. On the other hand, insularity relates to the notion that courts must not become grounds for realization of political aims. Insularity is believed to result, inter alia, from granting security of tenure to judges and providing significant checks and balances in their appointments. Both these attributes are important, but one more significant component which must be incorporated into any definition is the relationship of the courts with other parts of the political system and society. It makes the existence of significant levels of judicial independence contingent on the degree to which judicial institution has a distinct and discrete role. Such a role must be detached from the interest of the political system, the concerns of powerful social groups, etc. The role must solely be to regulate the legality of state acts, render justice, and determine the general constitutional and legal values. Judicial independence demands that judges need to be impartial and insulated from political pressures, and to be so within a broadly defined independent institutional scope of authority for the judicial branch. Judicial independence is the degree to which a judge decides cases consistent with his or her own interpretation of the law, sometimes in opposition to what others think or desire in like matters. The concept is believed to be closely intertwined with the doctrine of separation of powers, which have been adverted to now. However, it cannot be said that a strict separation of powers is a sine qua non for judicial independence. Independence of the judiciary is more closely related to the supremacy of the law. Supremacy of the law and judicial independence work together to guarantee rule of law, which cannot be eroded by political pressures in existence at any particular point of time. Both these concepts are therefore important underpinnings to the rule of law, which we cannot afford to take for granted. The next question which I would like to address is regards a relationship between judicial accountability and independence. Are these mutually incompatible values destined always to be in a state of tension? Alternatively, should accountability be viewed as a correlative obligation of independence, the one being the necessary complement of the other? In my view, these two values are to be perceived as complementary rather than antithetical. Judicial independence and judicial accountability are two faces of the same coin. But judicial independence is not designed as and should not be allowed to become a shield for judicial misbehavior or incompetence. Judicial accountability must run to the public, including the litigants whose disputes courts resolve. Public confidence in the judiciary was identified as a cornerstone of judicial functioning in the Federalist Papers. in the Constituent Assembly of India, Jawaharlal Nehru, who went on to become the first Prime Minister of India, underlined the need for judges to be persons capable of commanding absolute respect from the people and other organs of the government. Justice Frankfurter of the United Nations Supreme Court said, and I quote, "The court's authority, possessed of neither the purse nor the sword, ultimately rests on sustained public confidence in its moral sanction. Judicial accountability must also run to courts and to the judiciary as an institution, because individual judicial independence exists primarily for the benefit of institutional independence. In the ultimate analysis, judicial accountability is owed to the law itself. Accountability to the law, the idea that it is the duty of the judges to remain faithful to the law, has in its best intellectual expositions in the writings of Chief Justice Marshall of the United States Supreme Court. He conceptualized the idea of judicial accountability not as an accountability to any authority, but rather responsibility for carrying out certain objectives that the law espouses. Now, as far as the constitutional position in India is concerned, the most important aspect is the independence of the judiciary, which occupies a pivotal position under the Indian Constitution. The aim of the discussions in the Constituent Assembly in India was to reach a consensus on a system which would best ensure the independence and dignity of the judiciary as an anti-majoritarian bulwark in India's constitutional democracy, comprising of judges who, in the words of again Pandit Nehru said, would be of the highest integrity, people who can stand up against the executive government and whoever may come in the way, unquote. Now, the rule of law defended by an independent judiciary plays a crucial function by ensuring that civil and political rights and civil liberties are safe and that the equality and dignity of all citizens are not at risk. I would not like to go in detail with regard to the position of the judiciary in India as such, but I must highlight that the expansive interpretation of fundamental rights, judicial activism, advisory jurisdiction of the Supreme Court of India, and to a certain extent, judicial review of executive discretion and delegated legislation has made the court in India really powerful. How do we strengthen the independence of judiciary? Judicial independence is a multifaceted concept. There are different institutional, legal, and operational arrangements that in abstracto are designed to ensure judicial independence, and they can work differently depending on the historical, political, legal, and social context in which the judiciary operates. Every country has to find its own balance. In some countries, for example, judicial independence is basically secured through a self-governing body or council composed mainly of judges, which is in charge of all decisions concerning judges' appointments, nomination, career, transfer, and discipline. This occurs, for example, in France, Italy, Mongolia, Nigeria, Poland, Romania, Spain, and Ukraine. In other countries such as Kenya, South Africa, India, Germany, Austria, Czech Republic, and the United States, there is no equivalent body, and judicial independence is thereby secured through various other mechanisms. Therefore, what is deemed to be an essential measure in some countries may not be considered as such in others. This reveals rather different views on the institutional means needed to protect judicial independence. The protection of judicial independence is usually considered as including various aspects that operate at different levels, which I shall call as external and internal independence, and institutional and individual independence. External independence refers to the independence of the judiciary from the political branches, executive as well as legislative, as well as other non-judicial actors. Internal independence focuses on guarantees aimed at protecting individual judges from undue pressure from within the judiciary, from other judges. Other judges may, for example, exert supervising powers over court's administration. However, they must not in any way influence the substance of judges' decision-making. How can judicial independence be implemented in concrete terms? What are the basic arrangements that can be adopted to secure independence? The main factors that are relevant to promote and uphold the independence of judiciary can be identified as such, as under. 1. The procedures for appointment and transfer of judges. 2. The terms and conditions of judicial tenure, including protection of salary and allowances of judges. 3. Procedure for removal of judges. 4. Autonomy in court administration. And last but not the least, according to me, it is the personality of a judge. In addition to these, independence of the judiciary can also be strengthened by improving court management and administration. This is because a judicial system that renders justice in a timely, efficient, and effective manner builds public confidence and respect for the rule of law. The willingness and ability on the part of the judicial leadership to exercise stewardship in these areas has created a correspondingly increased willingness within the executive and legislative branches to commit funding. How the judicial branch governs and administers itself correlates to its independence. Again, if I were to identify one single aspect which would effectively safeguard and promote independence of the judiciary, it would have to be the personality of the judge. A judge should not, by word or conduct, manifest bias or prejudice based on sex, gender, religion, caste, disability, age, sexual orientation, marital status, socioeconomic status, and most importantly, political affiliation. Integrity and impartiality of judges are essential prerequisites, not only for the effective protection of the rule of law, but also to strengthen independence of the judiciary. An independent judiciary, we all know, is the ultimate shield that preserves and protects the rule of law in a democracy. However, as already stated, the ability of the judiciary to effectively perform its role as the protector of the rule of law is by no means automatic. Ultimately, the extent of independence of the judiciary relates back to independence, impartiality, and integrity of the men and women holding judicial office. It is therefore all important that meritorious judges are appointed who have the pulse of the society and the country in their hearts and rule of law in their minds while seeking to render justice. It is the personality of the judge that will determine in the truest sense the extent of judicial independence and autonomy. In my view, independent exercise of judicial power is not only a judge's prerogative, but also a judge's duty. From the aspect of judicial independence within the court system, separate opinions or dissenting opinions must be seen as an expression of mutual independence of the judges, that is, independence of a judge from another judge. This is independence of judiciary in its most enlightened note. On that, I conclude my lecture this morning with the firm hope that all gathered here will reaffirm our commitment to securing independence of the judiciary, remain alive to the insidious challenges that is being faced by it, and be vigilant in safeguarding and strengthening judiciary. With these few words, I once again thank the Commonwealth Lawyers Association and Mr. Santanakrishnan and Mr. Brian Spears for inviting me to deliver this address and to share a few of my thoughts. I thank you all for your kind attention. Thank you and namaskar.
I see Brian's lurking in the wings here, so I'm not going to be very long in just wrapping up. Can I say that the Goa Declaration recognises the connection between judicial independence and judicial impartiality? And also, as the speakers have said, judicial independence and impartiality impose duties on judges as well as on others, including the independent bar. And on this International Women's Day, I want to give a very short example of that in relation to Northern Ireland and the UK generally. In the year to March 2021, over 100 women were killed by men. There were nearly 900,000 complaints about domestic violence, mostly by women, and nearly 700,000 separate incidents of complaints of stalking, almost exclusively of women by men. Many of those victims have been reluctant to come into the judicial system, some because of humiliation, lack of support, intimidation, because of effect on other family members. But the issue is one of access to justice, and the judiciary, as well as others, have a duty to address that issue. We need to respect those who, for their own reasons, choose not to avail of the prosecution and judicial systems in order to assist them. But we must not fail those people who want to engage but do not have confidence in the system to protect them. We, as an independent judiciary, have to play our role. And in Northern Ireland, we have had a judicial-led project which has sought to address this in part by providing legal support directly to victims as soon as they become complainants in rape cases which are going to be prosecuted. And I hope that that may tend to give some support to those who are involved. But I personally do not feel it is sufficient. I think that complainants in serious sexual offences cases in Northern Ireland should have lawyers who have a right to make representations in court to judges on issues about privacy, on issues about the ground rules for hearings, on issues about the introduction of past sexual history evidence, on issues about the timing of the case and the degree of time that the victim is left without a remedy, as well as having direct access to the prosecution in cases where the prosecution are not inclined to commit to a prosecution. And it seems to me that it's difficult for us to engage in our outreach to schools, to community groups, and to the media to say that the system is fit for purpose until we have achieved that outcome. And that is an example which I think is pertinent on International Women's Day, but an example that talks to some of what our panel have said about the duties that go with issues of independence and impartiality. So with those few words, I'm going to hand over now to Brian, who's going to take us through the rest of the programme. I'm going to embarrass him very slightly by saying that Brian has been an outstanding advocate for Northern Ireland in the role that he's played within the Commonwealth Law Association. We have admired from a distance everything that he's done by way of his commitment, and I'm sure all of you will join me in wishing him well in his future role within the Commonwealth organisation.
Can I, on behalf of the delegates, just say, wow, what a tremendous start to the morning, what insights, what wisdom, what integrity, what wonderful examples of a truly independent judiciary. I feel that in any of the jurisdictions where you all serve, and where the judges who are listening this morning serve, that justice is well served by what we have heard. So thank you very much indeed on behalf of the delegates.